A breach of confidentiality is a disclosure of private information to a third party not involved with the patient's care without patient consent or court order. It can be oral or written. The Health Insurance Portability and Accountability Act was passed by Congress in 1996. The HIPAA privacy rule establishes national standards to protect individuals' medical records and other personal health information and applies to health plans. Patient confidentiality is very important. Patients routinely share personal information with healthcare providers. If the confidentiality of this information were not protected, there would be no trust in the physician-patient relationship, resulting in patients being less likely to share sensitive information which could negatively impact their care. Under certain circumstances, however, patient confidentiality must be broken. For example, cases that involve children, lawsuits, and health risks to a third party. Confidentiality is so critical, according to some therapists, the psychotherapy may be worthless without it. However, all states now have reporting laws which require therapists to break confidentiality and report any child abuse suspicious to law enforcement or child protection agencies. All state laws therefore require putting the child's best interests above the therapeutic relationship. These laws have resulted in enormous increases in the number of reports being made to protective agencies. Confidentiality does not prevent the professional from testifying in a court of law. There are 3 exceptions to the therapist honoring privileged communication. 1. When the court appoints a psychologist to perform an examination. 2. When professional opinion about mental or emotional problems may be necessary to assure proper legal handling or justice. And 3. When the client bases a legal claim or defense on his or her mental condition. HIV status and reporting requirements raise legal issues related to patient confidentiality. Legal protection of patient privacy and confidentiality depends on whether or not public health concerns outweigh the interest in preserving the doctor-patient privilege. All 50 states require both physicians and laboratories to report to local or state health departments the names of persons newly diagnosed with Centers for Disease Control. Partner notification is critical so that individuals know they are at risk, receive HIV counseling and testing, and get appropriate medical care. One of the most controversial issues is whether physicians may disclose the HIV status of their patients to known contacts, and further, whether failure to do so may give rise to liability if the known contact becomes HIV positive. Physicians have faced liability for not warning third parties of foreseen harm. For example, a California court held that a psychotherapist had a legal duty to warn a third party of foreseen harm, despite the presence of the client-therapist privilege. Many states have laws about informing contacts of their HIV exposure, and some health departments require that if a patient refuses to report a partner who may have been exposed, the clinic must report to the health department any partner of who the clinic is aware of. Doctors take patient confidentiality very seriously. However, from time to time they are faced with cases that force them to breach confidentiality to protect their patient or others. It is important to understand there are limits to patient confidentiality, and doctors not only have to look out for their patient's best interests, but the interests of others. It is their duty.